Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not
We will bring the jury.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy, do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy
They
there.
got the wrong guy, and the dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're getting commentary on the case. Dati mihi Anglican, please, verbal slap.
Is that correct?
I didn't ask you to interrupt me.
literally not true.
Oh, for crumb's sake.
All right, welcome to the Court of Public Opinion. I am the Recovery Addict. Welcome back on this fine Wednesday afternoon. Hope all your lunches were absolutely wonderful, except for Greeners. Sorry, Greeners. You've been busy fixing the internet ahead of this power outage. I'm sure you're getting a lot of calls about that. Big storm that's coming this weekend. Hope everyone's prepared. Greeners, hope you have the internet for the storm. I'm just saying. All right, welcome back. We're about to be going back to court in just one moment. As a matter of fact, we'll take a quick peek over there right now. And yes, we're just waiting the judge to come back in. All right, so let's turn the music down just a little bit. I wanted to show you. I told you I had to go fix the printer during the morning stream, the 3D printer, right? So I printed a thing, right? I did a thing. Let's see. Let's go here. This is a 3D print. This is the tray. This is what the printer prints on. It's a metal tray, and it extrudes this filament in this really cool pattern. This is the size of the. Oh, it's a weird color, see-through. This is the size of the insulin pump that they wanted me to build a case for. So I built this case. These trees are supports. We're going to break that off in just a second, like this. Comes off. Take that off as well. And anyway, we're going to get to court here in just one moment. Let's see. There we go. So that's the insulin pump, and then this is the bit that they want. You know, it's got the little belt clip. You can't see it very well because I printed it in green. Let's see. Let's just snap these parts off. Ouch. That part hurt. The tree supports. Just very pleasing to snap right off, and then you just have the remaining clip. It's coming together quite nicely. Little printing ASMR.
Please be seated and come forward.
All right. Are we ready for the jury?
Yes, ma'am.
Hopefully you got all your evidence in a row, Mr. Defense, because the judge is sort of sick of it by this point. She expects more from y'all. Need to polish it a little bit, but there's the clip that this snaps into. Beautiful. I'll have her test it out, see if she likes it. What do non-YouTube crime experts use 3D printers for? Weapons. Replicas of weapons.
All right. Your next question.
Thank you. Ms. Singley, good afternoon.
Good afternoon.
You listened to Ms. Groff's testimony yesterday, correct?
Yes.
Did you hear her discussion of
Gravity.
the position of Joe Ryan and the blood, whatever she called it, on Joe Ryan? Do you remember that discussion?
Yeah, you mean specific to his arm? Or is that what you're referring
Specific
to?
to his position on the ground.
Yes, I did hear her talk
Okay.
about that.
Did you agree with that?
That the bloodstains would indicate that he was lying on the ground?
Yes.
No.
And what can you point to in your expertise that would have you arrive at that conclusion?
So I guess starting with, I believe that she mentioned that the stains that were the 4 linear stains that I did not classify, she classified them. So that's where the first divergence was. So then that classification is what led her to say that he would have been in a position lying on the ground when they were deposited, if I recall correctly. So the first part is that as I mentioned before lunch, the target surface didn't lend to classification to start with, and to go on to then determine what that classification would mean in terms of his positioning is the part where it starts by the fact that I didn't believe that a classification could be made. Then to go on further to say what that classification would mean would be why I would disagree.
Okay. And was there evidence that you observed that would have support different conclusions than that, other than not being able to classify?
So maybe the best way to describe this is to have you understand what a drip stain is in terms of bloodstain pattern analysis. A drip stain is a stain that is formed by gravity alone. So it's not just a circular stain you see on a surface. It's a circular stain that arrived by a passive, formed by gravity. So it's not something that happened that's circular from another mechanism, but it just happened to hit the ground at perpendicular, making it circular. It is formed only through gravity alone. So the fact that I didn't classify it as anything was the first part. But then on top of that, if you have just the fact that something is circular does not make it a drip stain. It's one of the features you can look at, but it doesn't mean that it's a drip stain. So there are other mechanisms that when the blood is going through the air, say from an impact, say somebody was being beaten with a hammer. When the blood goes through the air, it goes in a parabolic arc, and if it doesn't hit anything in that trajectory, it will eventually fall to the ground, and when it hits the ground, it's going to look circular. But if it hits the wall on the vertical surface, it's going to look circular there too, because anywhere it hits a perpendicular, it will look circular. But we look at the size of them to kind of help to inform whether it could just be a drip stain, something that just was because somebody was standing over something and dripping blood, or if it was because of another mechanism. So because we didn't have a lot of these features, there was no classification done, because the size helps to inform that, and then the shape itself and the fact that we had this target surface to eliminate any of those other mechanisms, to only say that these are coming from drip stains and coming from above was part of the problem. Going further, if they were drip stains, it doesn't mean that because his arm was this way that he was down on the ground. It just means that the arm was in a position horizontal to where the passive drop was coming. Because people move around, your arm can be in, your body can be in different positions when you do that. So the orientation of your body and where that is in relation to where the blood is coming from is going to be how it will look like on that surface. But it's hard to then say, oh, the person was in this position just because there's something circular here that I think is a drip stain, and therefore because it's coming from above, he has to be on the ground laying down.
And if you were, as you've indicated in your previous testimony, that you would need more information, what more would you need other than what you just said in order to even make the determination?
Judge, objection calls for speculation.
You mean what? I'm sorry.
Objection calls for speculation.
I'm just asking her what other tools.
Overruled, that's fine.
Yeah, I think, I mentioned earlier, same answers as I would be looking at the size, shape, distribution, location, appearance. Those are the features that I look for, and determine that this is a drip stain to the exclusion of all other mechanisms. I would want to look for something that would look perfectly circular, that I could see scalloping all around the edges or spining around the edges, or it's perfectly circular on, like, say, a smooth surface, and that it has some size to it that would indicate that it's coming from just gravity forming it. If it's tiny, then, and I see it in terms of other, maybe in terms of other spatter stains in that area, I'm going to presume it's coming from or classify it as something coming from a mechanism that's a spatter-producing mechanism as opposed to just a single passive drop. So sometimes we can't tell. I mean, you know, we just have to look for those features and hope that if the target surface allows for it, we can classify it.
And in the absence of concrete information, is it appropriate to default toward a
Objection leading.
Sustained is to leading.
In the absence of additional information you want, how does one resolve that?
You go back to the higher classification. So if we start at bloodstain, and then we might go to a spatter-producing mechanism of some sort, and then we can classify that either to cast off or impact or expirated blood. If we don't have the features to meet those on each level of that, we revert back to the level that's higher. And so in this case, I just said, these are blood stains, and I described them. They were irregularly shaped, somewhat three-dimensional on the arm.
Okay, thank you. I have no further questions.
All right, cross-examination.
Good afternoon.
Hi.
So to stay with where we just left off.
Okay.
You're keeping it at the classification level that's up here because you don't have enough information to go a next step. Is that correct?
Yes.
But that doesn't inherently mean that that next step isn't a possibility, right?
Well, I don't consider the possibilities because if I can't go beyond the classification, then I didn't go beyond the classification. There's a reason I stopped.
Sure.
So I wouldn't.
But because you stopped, that then leaves all of the options still available. None have been excluded, correct?
You mean every possible mechanism that could possibly produce a blood stain?
Yes.
Yes, I guess, yes.
Yes,
Yeah.
including drops from above.
Yes.
Okay, thank you.
State won that one.
Going back for just a moment, you testified regarding the DLI lab, and you stated that the test sample was the pull from the genes avoiding staining. Is that correct?
I'm sorry, say that again. I didn't
You
hear that.
testified about the DLI DNA lab, specifically that the sample was a swab or a portion of Joseph Ryan's genes avoiding staining. Is that correct?
Avoiding staining, yes,
Okay,
I'm sorry.
but did you also read in the report that that sample was positive for blood?
Yeah, so it didn't say it was positive for blood. It said that blood was indicated in the sample. And so what that means is that they did a presumptive test. So that's a test that...
Right, we heard about that from our DNA experts. but-
so we didn't, the blood wasn't identified in that sample. It was an indication that there was blood there. And I think to clarify that the testing that is used in that instance is a very sensitive test that can pick up blood that
Judge,
you
I'm
can't
going to
see.
object. I don't think she's presented any foundation for knowledge of how the testing was conducted, and that wasn't my question.
All right, we're going to ask your question again. Let's go
Okay.
that way.
The laboratory result said that blood was indicated, yes or no?
Yes, that's not what you asked me, though. You said it was found. The test only said that blood was indicated.
Okay.
And yes.
Thank you. That's all I have, Judge.
Okay, any redirect? Is this witness subject to recall?
A little spicy.
Yes.
All right, so since you're
Subject to
let's
recall.
discuss your testimony with anybody, all right?
Okay, thank you.
Thank you.
Karen, if I can consult with counsel for
Yes.
just a moment.
I'm sorry.
The witness is not subject to recall.
Okay, you are not subject to recall, ma'am, so you're free to go if you wish. All right, thank you. All right, your next witness?
She's like,
Yes,
you're
thank
going to
you,
call
Your
him
Honor.
again?
Brendan Miller.
Brendan Miller?
I need like space for my paper.
You swear or affirm to testify truthfully in this case under penalty of law. Thank you.
You don't have to go away. You can start my Miller notes.
Laurie, send me a link to the article so I can frame it. Gotcha. Do you remember that song called there was a movie called Gotcha back in the day. Gotcha, gotcha where I want you. Too late to turn back now. Oh, do you remember that movie? I know it ended with somebody getting shot in the butt with a dart. That's all I can remember about it. I don't remember the important scenes. Quite impactful on my youth, I tell you.
Good afternoon, Detective Miller.
Good afternoon.
Can you please state your name and spell your name for the court reporter?
Yes, my name is Brendan Miller, BrendanMiller.
And where do you currently work?
Fairfax County Police Department.
And what capacity do you work in the Fairfax County Police Department?
I'm a detective in the child exploitation section.
Okay. During your, were you involved in this case as an investigator at any point?
Yes.
Okay, and what was your capacity as investigator?
I was the digital forensics examiner for this case.
And
okay, this will get
when
spicy.
Did that change?
About a year ago.
Sorry, almost there.
When did it change? Why did it change? Objection? Relevance?
Yes, ma'am. In child exploitation, do you utilize the same skills that you had when you were at digital forensics? I do.
Okay. And so when you left digital forensics, did you leave of your own volition?
I did not.
And was the transfer to child exploitation?
Yes, the transfer was to child exploitation.
Okay. How long had you been in digital forensics prior to being transferred?
Since roughly 2019, so about 5 years.
Okay. And how long, how many cases had you handled in digital forensics prior to that transfer?
I don't recall the exact number.
We're going into the spice now.
Were you the person who did the digital forensics in the Fairfax County Police?
One of them.
How many others are there?
There were 6 at the time, I believe.
And now when you were transferred out, this was in the middle of the investigation of this case, correct?
I don't know if I would classify it as the middle or where it was.
It was during the pendency of this case.
Yes, this case was still going on.
Okay. And in your capacity as digital forensics examiner, I'm going to ask you to look at a document.
So he was involuntarily transferred to child exploitation from digital forensics investigator during this case.
Judge, do you see anything on the screen?
Just your screensaver.
Okay.
I think he's talking quietly because he's under oath. He has to testify against his bosses that he currently works for. He doesn't not have a choice in the matter. I'll bump the volume a little bit, but it's already high.
That's all right.
That way, if they hit the microphone, we'll all go deaf together.
Okay. Sir, can you see that on the screen?
Yes, sir, I can.
Okay. Do you recognize that?
I do.
Okay, and what is that?
That is an executive summary.
And this is an executive summary that you wrote as digital forensic examiner for the Fairfax County Police?
Yes.
Did you want to mark that as a?
Yes, Your Honor. 85, please. Offense
85 for the
85.
record? Just thank you.
And sir, this is your personal digital forensics executive summary, is that right?
I created this document, yes.
Okay. And now, in arriving at these conclusions, this was related to your work as a digital forensic examiner, correct?
Yes.
Okay. Your Honor, I move this in as Defense Exhibit 85.
Any objection?
Yes, Judge. At this point in time, I think this would qualify as an expert report. This witness has not been qualified as an expert, nor has any foundation been laid for the report.
Okay, so foundation is
What?
the objection, so I'll sustain that objection if you want to lay it.
I can do that.
Sure.
So, sir, tell me about your experience in digital forensics.
In what regard?
From the moment you got into digital forensics, what kind of training did you have?
I've received training in a variety of forensic tools and training specific to computer systems, specifically the International Association of Computer Investigative Specialists, IASIS. I've also been trained with Cellbrite and I'm current in both of those certifications and training with Magnet and X-Ways and various other forensics platforms.
Okay. And did you receive additional training beyond that within the Fairfax County Police?
I'm also certified for BERLA, which is the vehicle forensics. Various other trainings at different times.
Have you ever been qualified as a witness in the courts of Fairfax County?
Judge, I object to the question.
Qualified as an expert, I'm sorry.
Yes, I have.
Okay, how many times?
2 that come to mind.
Okay, and was that in your capacity when you were a digital forensic investigator?
Yes.
Okay. Your Honor, I move Detective Miller in as an expert in digital forensics.
Any objection?
No objection.
All right, so moved.
Now, sir, is this report the report that you created?
Yes, I wrote this.
And when was this report created?
I don't recall the exact date.
Okay. Was it prior to October 25th, 2024?
I don't recall exactly, but that sounds about the right time frame.
Okay. And that's a significant date because that was the, if I can remind you, the first recant for Juliana Perez Magalhaes. Does that give you a better idea of when this would have been done?
Objection, leader.
I don't. If memory serves, this was done prior to that.
Okay, that's all we can rely on is your memory. And Your Honor, I don't have any further questions.
All right. You have any cross-examination?
What?
I mean, Judge, I would note that, no, I have no questions at this time.
I would note that, no, I have no
Is
questions.
this witness subject to recall?
Yes.
Okay, sir, since you're subject to recall, you cannot discuss your testimony with anybody. You do not need to stay here today, but just be on call. for
Okay,
that,
we needed him
You're
to
still
open
subject
a
the
door
rule.
to something?
Okay?
Yes, Your Honor.
All right, thank you. All right, your next witness?
Harry Lidsky.
Harry Lidsky? Hang on. Give him time to develop his argument here.
Do you swear or affirm to testify truthfully in this case under penalty of law? I do. Thank you.
We might see that dude again. He's subject to recall.
Sir, can you please state your name and spell it for the court reporter?
Harry Lidsky, Harry, as in David, SKY.
And how are you currently employed?
I'm currently a private investigator and digital forensic examiner, self-employed at my company, 4DIS.
Okay. And
for this case.
What's your background in terms of digital investigations?
Please let go of the mic, sir. It works
and
just fine.
investigations? Prior to starting my own company, 4DIS, I retired after 20 years in federal law enforcement, 7 years with the DEA, the Drug Enforcement Administration, the remaining 13 years with the U.S. Department of Justice, Office of the Inspector General. For the last 11 of those 13, I was in the Cyber Investigations Office, where I progressed as a senior special agent to the assistant special agent in charge and retired as the special agent in charge of that office. The Cyber Investigations Office handles, as the name would imply, digital forensic examinations. We're responsible for supporting the entire agency nationwide with mobile and computer forensics, basically anything with an on-off button, anything that was electronic in nature, is where we came, our services were brought to bear.
So
on top of that, we ran our own investigations, those specifically which were digital forensics centric.
And in terms of issues, have you ever heard of catfishing?
Yes, I have.
Have you worked within investigations where it's alleged or it's found to be catfishing?
Yes, I have.
So do you understand the elements necessary for catfishing?
I do.
Describe for the ladies and gentlemen of the jury what that exactly is.
Well, you need a fish.
It's a form of misattribution in terms of who's performing what activity. So at its core, it's somebody pretending to be somebody else, usually designed to lure somebody else to do something. It can be employed in a scheme to defraud. It can be employed to get somebody to show up, to get them in trouble, to get somebody to show up to an event they had not intended to show up at, to misdirect somebody to show up for something. A case that I worked, it was employed to misdirect somebody to show up who thought they were coming for a consensual sexual encounter, not unlike this particular case. And in fact, they were there to serve a different purpose, to be set up as a victim, as a utility or a tool in that particular investigation.
So in that particular investigation, was that from the prosecution side or the defense side?
That's when I was a criminal investigator, a federal agent for the Department of Justice.
Okay. Now, in terms of your investigative experience, even beyond digital forensics, can you tell the ladies and gentlemen of the jury what kind of experience and what kind of responsibility you had while being a federal investigator?
Well, in addition to the digital forensics, again, 7 years with the DEA, it was drug law enforcement, pretty straightforward, what you'd think, what you'd expect, I guess, between the street level version of it. Domestically, always working our way up towards the source, back to the cartel sources, and usually overseas. But through that, I gained experience with interviewing witnesses, interrogation of subjects, obviously arrest tactics and things along those lines. But there was also a strong money laundering component involved with that. There was surveillance skills were heavily employed during my time with DEA. I did a lot of undercover work with DEA. At the DOJ OIG, the Department of Justice's Office, the Inspector General, we were the watchdog for the Department of Justice. So we investigated both administrative and criminal waste, fraud, abuse type misconduct that occurred within the Department of Justice, that is, employees of the Department of Justice, or also from external actors affecting the business of the Department of Justice. And through that, we did a fair amount of investigations, to the extent that makes sense. There was a number of high-profile investigations. Fast and Furious might be one of those.
That was a
where
movie.
our investigation was aimed at the investigation or the operation conducted by the ATF in that particular instance. And we would often find, we would make assessments, recommendations, and even punishment recommendations for employees that acted either out of malice, ignored or abused policy, whether they engaged in misconduct inadvertently or maliciously. Those were the type of findings we would have. So if we found that an investigator failed to adhere to policy, we might have a finding. If we find an investigator lied to us, or in an investigation, somebody within the purview lied to us, we would find they lacked candor. So we, our reports, our investigations resulted in terminations of employees. Sometimes they were
prosecutions,
at this
objection
point in time, I
relevance.
think we've launched into a narrative that is not responsive to the question, nor is it relevant.
All right, if you want to ask the next question.
Well,
continue on that.
It was a question about your investigative background, so please continue.
Yeah, so that was the gist of what we did. So it's pretty broad spectrum of investigative experience. That added component from the OIG of having the investigative oversight and the watchdog to include over investigations and other police officers, other federal agents, other prosecutors, was a nuanced twist, I suppose, in my experience there. In addition, there was the more traditional, straightforward investigations we conducted, to include everything from white collar, bribery, catfishing, international money laundering, conspiracies, and the normal type of white collar crime.
And in terms of your investigating the investigation, you were actually dealing with law enforcement people who came.
Objection leading.
Explain what you did in terms of the investigation of the investigations.
Sure. DOJ is huge, the biggest law firm in the world, as we like to say. DOJ includes the FBI, the DEA, the ATF, U.S. Marshal Service, Bureau of Prisons, U.S. Attorney's Offices, Interpol, and about 40 other smaller components, tax division, civil rights division. So we're a massive agency far and wide. So we were made up of federal agents, FBI, DEA, ATF, and the Marshals. But we were also made up of attorneys. We were made up of auditors. We were made up of all sorts of employees. We had IT employees engaged in inappropriate network activity where they were reading other employees' emails improperly and illegally.
That's what they were paid to do?
Whenever somebody was accused of misconduct, whenever an allegation of misconduct came our way, we would take that on. So it can take all forms.
Now, going back to the digital forensics investigations, you indicated you were there for 11 years?
Yes, sir.
Okay. And during that period of time, were you ever qualified as an expert in the court of law?
Yes, I have been.
Okay. How many times?
I say 3 or 4 at the federal level, and once since retirement here in the Commonwealth.
Okay. Your Honor, I'd move Mr. Litsky in as an expert in the fields of digital forensics and general investigation.
And general investigation?
Judge, I'm not familiar with general investigation as an expert field, but certainly digital forensics we would accept.
I'll move in as for digital forensics expert.
Yes.
Okay.
Sir, you became involved with the Banfield case.
I'm an expert in general studies.
The first thing that you did when you started reviewing evidence?
The first part of my evidentiary review focused on the digital forensics. I was provided with a rather large, volume-wise hard drive, 8 terabytes, I believe.
And the digital forensics, and I guess, Your Honor, I would just state that the digital forensics that are the foundation have all been stipulated to in the stipulation document in terms of
In terms of a report of a digital?
In terms of the the data that was taken from the devices?
Yes, Your Honor, we have stipulated that the raw data pulled from the devices does not need to have a chain of custody or
Okay,
foundation.
so he can talk about the raw data from the
Correct.
devices. Okay.
Yes. And so, sir, what's the first step in your analysis of digital forensics?
You pee in the bottle.
When you get involved in the case.
Oh, wait, sorry, wrong question.
Well, in this particular case, it was atypical because I didn't have to perform any of the acquisition phase of it. Detective Miller had already performed all of the digital forensic acquisition. So what I was provided was generally the derivative elements of his work, which allowed me to just jump right in and review the various artifacts. When I'm performing a digital forensic exam that's derivative of somebody else's work, I make it a point not to review their findings. The reason being, digital forensics is semi-analogous to solving a big math problem. So to perform it accurately, or at least the way I like to perform it accurately, I like to do the work myself, see what answer I come up with before I see the answers of somebody else's work. Digital forensics is a science such that we're all trained similarly. We all take the same training. We all operate the same way. If we perform our actions as we should under the guise of best practices, we should do the same thing, each one of us, and come up with the same results. Digital forensics is repeatable. Digital forensics, it should be. It's binary. The data is the data. It's not subject to interpretation. It's not subjective. So what you see is what you get. There are nuances in understanding it and what it means. Assigning attribution is a different phase of it, but and we'll eventually get past this boring stuff and see some of it. It does reveal what's going on behind the screen, typically on either a phone or a computer.
You just want a soundbite? Eventually we
Now,
get past this boring stuff.
Digital forensics in this case, how do you arrive at certain conclusions?
So, digital forensics, like most of the forensics, and we've heard a fair amount here so far in this trial, it's supportive. It can be informative. You can draw certain conclusions, but they're based upon the results of the digital forensic analysis and its impact on other items of evidence or other items of investigative nature. And what I mean by that is, for example, if somebody says, if we're investigating a crime that took place in Boston, and somebody says, I have an alibi, I was in Miami, and I look at their phone and there are artifacts that reveal location information in Miami, that is an informative piece that says this individual, based on their phone, might have been in Miami at the time. Now, phones can travel without, are traveling with them. So was the phone there? Was the person there with the phone? So that's a lead. That's a pointer. The follow-up to that would be, okay, do we have airline records? Do we have video surveillance from an airport? Do we have video surveillance from a hotel in Miami? Do we have credit card transactions from a restaurant in Miami? Other indicia of location. So digital forensics is informative. I guess if there's enough digital forensic pointers that can, I think pass a test, then it can be conclusory as well, and we can draw conclusions from it.
And in your example of something in Miami, when you arrive at a certain number of artifacts that say the person's in Miami, is that it?
It can be. That's probably a bad example in terms of being conclusory. If somebody says, there's no pictures of a red sports car on my phone, and I find 100 pictures of Ferraris that are red, that's conclusory to say that the witness information or the interview subject information that they provided to the investigator, whether it was me or somebody else, is clearly wrong. Now, that doesn't get to whether they misremembered, whether those photos are old, whether they were taken by somebody else. So there's still an attribution aspect, but it can be conclusory or informative in that regard.
Okay.
High performance
Now,
exotics.
in the context of this case, what were you trying to determine based upon the theory of the Commonwealth in this case?
So this case, I've the luxury of coming in at after the things had developed. The theory had already been assigned. Catfishing was already Mr. Banfield had been charged already, and indicted under a catfishing theory when I was brought in. So that was my immediate focus. So confirm or refute that theory. As an investigator, whether I'm in my law enforcement capacity or now in my private capacity, the facts don't change. The facts are the facts. Facts don't take sides. The truth doesn't take a side. So for me, just because I'm hired or asked to investigate one particular theory, it doesn't mean...
Judge, I would object at this time. This is non-responsive.
All right, I'll sustain as non-responsive.
Okay.
You want to ask your question?
Sir, in terms of what you did when you started this investigation into Christine Banfield's devices, what did you do?
So I started evaluating the devices, but at the same time, I reviewed other evidence that was available to me provided in the discovery. That would include witness interviews. That would include subject or co-defendant interviews. That would include social media type event like email, Instagram, Facebook, things of that, WhatsApp. So it's not all a device centric. It can be evidence provided by a service provider like Google or Apple. I reviewed all the photos from the crime scenes, the autopsies, the digital, the forensic science and Office of Medical Examiner. I reviewed all of the facts available to me. The best way to perform what I do is through all source
Judge,
analysis.
objection, non-responsive.
I sustain the objection.
Okay. So in terms of the items that you were just telling the jury that you review,
Definitely paid
did
by
there
the
come
hour.
a time where you were reviewing and were able to arrive at conclusions?
Yes,
Yes
I
or no?
was.
Okay. And specifically, what date range or what period of time were you looking at?
So the window of time was from January 9th, 2023, specifically with regard to the catfishing, was from January 9th, 2023, obviously through the time of the event on February 24th, 2023. It did extend back a little bit further. For example, the discussion about the windows, that dated back prior to January 9th. There was witness testimony or subject interview, transcript information about planning that predated January 9th. So I don't just look at it at a time. For digital forensics, it's important to look backwards for a certain relevant period to ensure that
Objection, non-responsive.
Sustain the objection.
Why
He just
why
keeps
would
talking
you look
until she
backward in a
objects.
digital forensic analysis?
A single artifact, as we refer to them in digital forensics, it may not be informative, right? A single text message on this day may lack the context, but the 50 prior exchanges might help that context, right? That's relatable, and the communication after that might also help inform. So it's important to look backwards. It's also important to look forwards in digital forensics. And when we're talking about, in this case, the allegation of a conspiracy that lasted a period of months, I find from an investigative perspective that it's important to look at everything. Digital forensics, like any, I think, informative piece of evidence.
Objection, non-responsive.
There it is.
Sustain the objection.
In the context of certain behaviors that come up through the investigative process, like, for example, when someone may have had their phone in their laptop and when someone would have been away from that, are those things that you look at?
especially for events like that, what was happening immediately before the event is vital in determining attribution or who might have been performing what activity on a device.
Or saying in another way, would there be...
Objection leading.
I haven't heard the question yet.
What would you do if there was a pattern of time that needed to be analyzed, or a time of day, or a certain day? How would you go about doing that?
Well, with the digital forensic tools that we have, the software that we have, we're able to visualize things in a timeline fashion. So I'm able to look at, or folks in my profession are able to look at what happened, both what the user was doing and what the system was registering, the computer system. So we're able to generally create a granular timeline that helps inform a decision or conclusion about whether a device might have been removed from one person and used by another.
This could be huge if they can prove that.
Can you see the document that's on your screen?
Computer.
I see Detective Miller's executive summary.
Yes.
Yes.
Have you had an opportunity to review that?
I have.
Your Honor, can that be published to the jury?
It was not admitted into evidence.
Okay. I'd move it into evidence.
Objection, Judge. It's a hearsay document at this time.
I'll sustain the objection at this time.
Detective Miller testified to it.
If you want to approach.
I think the state just legally maneuvered to a great point. They made him an expert witness. They admitted the previous guy as an expert witness. He testified to the report. It was an expert report, which is hearsay. Reports don't come in. Now he tries to use that report to use for this witness, and boom, you can't. You can't. It's hearsay. Should have been admitted as an official document. That was a huge loss for the defense.
Mr. Litsky, I'm going to go to... Sorry.
That was high-level chess. You wonder why the state wanted the last guy admitted as an expert, and that was why. They're 4 moves ahead. Just chopped a huge section out of this witness's testimony. Maybe all of it.
Can you see something on your screen there, sir?
I can.
Okay. There's evidence in this case regarding window replacement that was communicated by Juliana Perez Magalhaes. Do you remember that?
I do.
Did you do a digital examination? Did you do a digital examination as to the allegations that she made with regard to window replacement?
I performed searches relating to that particular topic. I'm able to perform keyword searches as one of the search criteria. So I did perform searches related to that particular part of testimony, yes.
This witness has Google.
And was this part of the information that you'd received from our discovery and the data that came from the devices?
Yes, it is.
Okay. I'm going to have you look at the document that's on your screen. Can you, Your Honor, I'd identify this as Exhibit 86.
All right.
Can you look at Defense Exhibit 86 and explain what we're looking at here?
Judge, I'm going to object to any statements regarding what's contained in the document.
Are you moving it into evidence, Mr. Carroll?
Yes, Your Honor.
Any objection?
Yes, I would object to foundation. We have not been given any information about this
Sustain as
document.
to foundation, if you want to lay a foundation.
Sir, how did you find these documents and what processes did you use in order to find this information?
So based on the derivative evidence provided to me in discovery on this case, I analyzed this particular one. This came from Ms. Banfield's cell phone.
Judge, I'm going to object to that conclusion. Again, there's been no foundation laid, and we can approach and I can explain further.
Are you want to approach?
The state is winning this battle. This is legal chess. It's not evidentiary. It's not. I mean, by that we're not comparing different pieces of evidence to see whether it was a whodunit. This is using the court system and the rules of evidence admittance in court to win an argument, to win an exchange, and the state has this in spades. I think. I don't think this is coming in. It's the wrong witness to admit it, I think. So he can't lay the foundation with this one, saying someone gave me this document and I looked at it.
Sir, what was the raw data that you used in order to get this, and what system did you use to arrive at this?
This was from an Axiom portable case created by Detective Miller. An Axiom portable case is a derivative product from Magnet Axiom for digital forensic software, which performs mobile and computer device review, or facilitates mobile and computer device review and cloud review and all things digital. So the software is baked in. It's an executable program that comes from the main Magnet program. So Magnet permits digital forensic examiners, in this case Detective Miller, to create a derivative subset of his work that is able to be open on any Windows computer. So you don't need to have a software platform. It is a software platform.
And if you can tell the ladies and gentlemen of the juror, or Your Honor, we move that in as comes our defense
Same objection.
If we could approach, please.
We're missing the key foundational elements for this document, I think. I don't think this one's coming in. Defense is struggling here. Brendan, not the one on the stand, the other Brendan, or not, I guess is this Brendan on the stand? No, this is Harry Lidsky. Brendan might be kicking himself. This attorney should be able to get past this with proper planning and preparation. Not just expecting to be able to just throw documents up on the stand. Yeah, now he's nervous. Look at that. I think he's nervous. We might be done a lot sooner than expected. Ineffective assistance of counsel? I don't know. What's he thinking? The struggle is real. Just a tad nervous. Yeah, he's definitely nervous. The GQ officer behind GQ pose. What's frustrating about this is a tactic to keep scientific evidence out, right? This is evidence about Christine's phone, what it was doing, where it was, what it was being used for, what records it kept with timestamps at different times. If they can show that her phone was, doing a specific thing or at a specific location, that can help prove or disprove that the computer was used at that time. Judge shook her head. I don't think she's going to allow it. I don't think it's coming in. Oh, man. The officer is hoping to be discovered. Who do you think? Is he posing for Time Person of the Year? What's the officer going for there? Extras Are Us, the movies. GQ. The precursor evidence to this basically promised us that we'd get to hear that from the digital footprints, evidence that would tell us who was using the computer. If that evidence tells us that Christine was using the computer at the time that these FetLife messages were sent, like if she's accessing other password-controlled systems that she accesses at work and everywhere else.
All right. So the objection is sustained.
Sustained, not coming in. Oh, crap. Right, Mr. Brendan?
Sir, did you work with the raw data that was provided by the Fairfax County Police through search warrants and other providers?
You better
things
say
like
yes.
For search provider, for service providers, yes. The records I had were responsive from Google, Apple, Facebook, and Instagram, FetLife, and others, Discord. For the computer and mobile devices, I was not provided the raw data. I was provided the derivative work, the portable cases, the Celebrate readers, which to my understanding, is the complete device. Nothing is filtered out, but I wouldn't characterize it as raw data.
Your Honor, may I just request a 10-minute recess?
We want to do our afternoon recess? We can do that.
Yes.
Okay, let's go ahead and take our afternoon recess for 15 minutes, ladies and gentlemen. And we will get right back to you. Again, don't do any outside research and don't talk to anybody, okay?
If that isn't a terrible sign for the defendant, I don't know what is. You walked through very quickly through a series of witnesses to set up this expert. And the state shot down the reports that you want this expert to testify to.
All right. Sir, since you are in the middle of your testimony, you can't discuss your testimony with anybody to include the defense at this point, okay?
Of course, thank you.
All right, we'll be back at 3:15.
All right. The defense. So now he's sitting here thinking, what do I do now? What do I do now? I need 10 minutes to write my, Your Honor, I'd like to withdraw from this case. There's part of me that, as you know, a potential juror wants to know everything, right? I want to know all the information, everything that applies to the case, every bit of detail I can, so that I can see for myself where the evidence leads us, right? There's a part of me that wants that. That's not the way the courts work. Everything isn't admissible. Some things aren't relevant. Some things aren't admissible because of hearsay or some other rule. And it's those rules of what is allowed in and what is not allowed in that have brought us to this point right now, where the defense is up against those rules and can't bring the documents, the reports that we had, you know, what was his name? Brendan, the other Brendan on the stand, look at and say, yep, that's the report. That's the report I made. The detective, right, who wrote a report, the one who was the detective on this case who wrote a report. For some reason, the state said, you can't bring that in. He's not an expert. And he's like, let's qualify him as an expert. They qualified him as an expert. Now we can bring it in and he can talk about this report, but not as evidence. It can't be put in front of the jury. Expert reports are not evidence. So he tries to show this to the witness here and says, tell us about this report. Tell us about these conclusions. And we can't do it. You can't get there. And he's lost on 2 counts so far. I don't think there's much more. He's asked, when he said, have you looked at the raw data? Okay, he's basically waving the white flag saying, forget about all the expert reports and their conclusions, which we wanted in. Please tell me you looked at just like the spreadsheet that had all the information and you got something from that. He's like, no, I pretty much, I looked at, not Cellbrite, I looked at Verizon and FetLife raw data, but the conclusions and everything, he didn't. He looked at derivative stuff. And it's not coming in. It's not coming in. And now he's spinning his wheels. He's pausing. He's asking for a break because he has to regroup. He has to rethink and figure out a way to move forward. Now, it's possible he might be able to go back and some of these witnesses that he had on the stand that he released or didn't release, as the case may be, he might be able to call them back and claw back some ground there. But he can't really go forward with these documents with this witness. Do we think Brendan will testify? He might need to now. I thought experts could talk about other experts' reports, though. Yeah, to an extent. But you can't put that report in front of the jury as evidence and show them something. He never asked to admit it. He did ask afterwards, and the state objected and said, no, it's hearsay. Expert reports are hearsay. I don't know why it's hearsay. I don't know why it would be considered an expert report. This was the investigator on the job who wrote a report about his work on the job. Now, the date of when it was written, that part confused me because the date seemed later, right? It seemed like maybe he wrote this on his own on the side. If that's the case, then it's not an official document, right? But he can't bring it in as an official document, which would be evidence the jury could look at, and he can't bring it in as an expert report because it's hearsay, and now we're stuck. So he walked into the trap. The state played him like a fiddle, and he fell for it. Because at that point, he was trying to admit to the other guy's report as evidence with this witness. Yeah. It almost doesn't seem fair. This part frustrates me a little bit, right? Because we know that we're talking about digital data, digital evidence. We should be able to see it. The jury should be able to see it because this can either prove or disprove that something happened. Say, for instance, in this digital evidence that they've got, there is something that shows that that the computer, before, during, and after FetLife messages were exchanged, logged into the hospital network using, the two-factor authentication. That would indicate that the user on the computer also had access to the hospital network and knew the two-factor authentication, whether it was a fob or password something you have, usually is how that works. And that would indicate that Christine would be the person using the computer. It wouldn't be reasonable to suspect that Christine logged into the hospital network, gave the computer to somebody, they did a FetLife message, she got it back, did some more hospital stuff, gave it back, they did more FetLife, she got it back, gave more hospital stuff. It would blow the state's theory out of the water if that's what's happened. I'm not saying that is, but they sort of set it up saying that this evidence will show us that, but we don't get to see it. So I am a little frustrated that the state was very. I'm proud of the state for what they did. That is a legal maneuver that gets you big raises and promotions around the law office. Being able to win a battle using the rules is a win. A win is a win. But the part of me that says the state should be seeking for justice and not picking a side says, why can't we see that? All right. Expert Brendan, he couldn't have admitted it because Expert Brendan said it was an expert report, which is always hearsay. Expert reports don't come in as evidence. Judy, we probably got the most spice this trial's had in quite a bit. But yeah. I want to know what the IP addresses used during certain time frames and compare to known whereabouts for people. Yeah, do geolocation on IP addresses. If the FetLife stuff happened, well, the computer was at the hospital or wherever Catherine worked. Kristen. No, I can't. I'm losing my mind. If the wife used the computer at work to do FetLife messaging, that we should hear about that. I also think that if that had happened, the state would have to disclose that as evidence to the defense that could exculpate their client, and they didn't do that. So I don't think that's what happened. Don't forget, Brendan is law enforcement of the IRS. Downloads are his forte. He knows this stuff. I think I think he knows right now what a difficult position the defense team is in with their case in chief. I think Brendan understands that very well, and he might be a little upset with his attorney. Missed the whole day, should you go back? Always. For those that want to recap, I strongly recommend going back and watching it from the beginning every day. Unless they had their telephone for two-factor authenticator. It's possible, but then you can also look at the phone and say, is the phone at work? What's the geolocation of the phone at that time? Where was it pinging? Where did the cell towers show that it was? What networks was it connected to? All my passwords are saved in Chrome, so if you can open my computer, you can access anything that has a password. It's always good to have that locked up a little bit. See Lizzie Yordy's comment. This one or the previous one? Let's see. Please just quickly watch the end of The Last Witness. We just watched that. Are you saying just catching up? That's what you should watch? If I only had that kind of replay time. I know, but the problem I have is I can't replay and recount everything that happened in the trial and the break we have. So I'm sort of torn between discussing where we're at and what's coming up next and going back for the people who missed it. So I try to balance that a little bit. If court watchers know all this, the attorney should know much better. All right. Yeah, we stay live. We're not going back. I can only imagine the conversation they're having back there, sweating bullets. I think this attorney is sick today. I think he's been sick for most of this trial. Maybe it's just a cold or maybe it's been the flu, but we've had sniffles and coughs the whole time. I watched up to lunch, had to jump off to my own work. Yeah, it got a little spicy. All I'm saying is that the defense is calling a series of witnesses. They've introduced the idea that there were problems in the investigation, that people got fired, or not fired, but got transferred against their wishes out of this investigation during this investigation. And then we've got this report that they wrote about the investigation. We tried to bring that in. They said, you can't bring that in. He hasn't been he can't talk about that. He's not an expert. They made him an expert. He brought it in as an expert report, which is hearsay. They can talk about it, but they can't present it as evidence, can't be admitted in front of the jury. Then they tried to bring it in and show it to this witness to have him talk about it. They're like, I'm sorry, that's hearsay. You can't be telling us what's in that report. And now defense is a little bit stuck. Of course, this expert's going to say that everything done to arrange the encounter with Joe was done on Christine's devices, so can't exclude her as the one who did it. Yeah, I don't think they have any smoking gun. Hey, did it print? Is it done? Not yet. Is it still going? Okay, awesome. All right, all the doors are closed for defense. They're shutting fast. He was almost, you could hear him imploring in his voice as he's asking the witness, did you look at the raw data? Did he look at the raw data in this case? And he's like, well, I saw some of it, but the parts that matter that he wants to get to, he didn't. He looked at the reports. He looked at the summations. He did preserve the last guy for recall. Then they might be able to call him back up and get some of it from him, possibly. All right. Do you think this could affect the jury if the jury thinks there could be more to the story? Yeah, but the jury should base their opinion on the evidence presented in court. I'm a big believer of that. You can't base your opinion on what we didn't see unless of course that's a bad example, because that's the argument that we hear in a lot of defense cases. Don't just listen to what you're told, but listen to what you're not told. I think the jury could have reasonable doubt if they believe the state has not proven this case, that there are elements of the case that the state just didn't address. That they're like, why are we left with so many question marks at the end of the state's case? Why didn't we hear from the investigators and things like that? Maybe. I thought he changed and said no about recalling the last guy. That was my understanding, that they released him. He said, yes, subject to recall. The state said, Your Honor, if I can talk to counsel. The two got together and talked, and then they released him. Oh. The last guy was subject to recall, but then as he was leaving, I think they released him. The expert was released. No, that was the blood lady. Thought that was a lady. Okay. I'm mixing them up. They're in serious trouble. That was the guy before. You get the from like Liar Liar or whatever, the movie. It's like, Your Honor, I object. This is harmful to my case. I think at some point the sidebars today, defense has got to be looking at the judge with like puppy dog eyes and saying, Judge, please give me this one. I need it. And she's like, nope, them's are the rules. I think Brendan's next because it's devastating to my case. Let me, in this little break, let me just tell you what our plans are going forward. I don't know what the weather is going to do, especially for this case here in Virginia. Virginia, one of the states that might be hit pretty hard by this storm. We know that there will be scheduled court for tomorrow, which is Thursday, but then no court scheduled on Friday. We still work Fridays, so our plan is to go back on Friday and catch up like we did last week on the other trial, which is still running. The one up in, it's not Ohio, New Jersey, right? It's New Jersey. So we'll catch up there on Friday and on Saturday, barring any unforeseen weather circumstances here where I don't have power, because it might be bad here as well. So we'll catch up there, and then we'll come back here when it returns. So we need Weather Watch to give us an overview. Oh, look at that great picture. Some of this artwork is fantastic. That's a nice portrait. Hands clasped, almost in prayer. Defense is sweating bullets. I heard that we're getting hit hard with the storm, but honestly, I'm right on the coast almost. I'm an hour and a half from the coast, and some of the weather maps. Oh, it's Mr. Queen. Some of the weather maps don't even have us
All right, we're ready for the jury?
getting frost.
Yes, ma'am?
Or getting rain. The jury room must be just off this courtroom. They're so quick at coming in. Judge does a quick head count. Looks like everybody's here. Y'all take your seats. The defense raises.
See, your next question.
Judge, I don't have any further questions for Mr. Litsky.
All right.
I would ask to recall him at a later time.
Okay, well, cross-examination?
Not at this time, Your Honor, no, thank you.
Okay, all right. Sir, since you are subject to recall.
That was a victory
not
click of
discuss
the
your
pen.
testimony with anybody, and you may be recalled, okay? But you can have a seat. Thank you.
All right, call Detective Miller.
Detective Miller. Again. He was just sworn. Yeah, okay. Yeah, he just, perfect.
Are we going back?
He's already been sworn.
He's already been sworn.
All right. Detective, just a reminder, you're still under oath, okay, sir? Yes. All right, thank you.
You're back. Let's see if they can let him in as an official document.
Detective, can you see the document that you had created? Yes. Digital forensic summary? And when you obtained the data in doing your forensic analysis, describe for the ladies and gentlemen of the jury what you do.
Make sure the green button's on there.
Okay, I think it's on now. In obtaining data from a device, the first thing we do is stabilize it, and that method depends on whether it's a mobile device or a computer, whether the device is on or off. So an example of a computer, what I would do is the device, if it's already coming to me in a powered off state, I would remove the hard drive, connect it to a forensic machine with a write blocker. A write blocker is a device that prevents writing to that evidence device. Therefore, no bits are changed, so no zeros, no ones, nothing gets altered. And then I take what's called a forensic image of that and create an evidence file from that, which is then loaded into another forensic tool that will parse that data and create it into a readable format for me as the examiner or anybody else to read down the road.
And would you draw your conclusions that are the conclusions that are on this digital forensics executive summary after doing that through different artifacts?
Yes, I would draw any conclusions off of data that had been obtained from a device.
Okay, and what you just described to the jury is what went into this document, the digital forensic executive summary.
Everything that was used to compile that came from data that had been extracted from the digital devices.
Okay, and specifically relating, and I'm referencing this document, January 9th, that was an important day in terms of who was using devices.
Objection, counsel's testifying.
All right.
What's the significance
I'll
of
state objection. Go ahead.
Yes. What's the significance of January 9th, 2023 in this investigation?
That was a date that a Gmail account was created.
Okay, and in your investigation, were you able to determine who created that account?
Who in particular? No.
Yes. Were you able to investigate using your tools to determine artifacts such as who such as other lifestyle type matters as to who was home, who could have been there, things like that?
Judge, objection is to form.
If you want to state that question again.
What are the things that, so when you're honing in on who was using a device, what things do you look at?
I would look at a variety of things. Pattern of life would be a term that would be used, but you would explore all that the data has to offer and see if there's enough artifacts there to support or provide enough information as to who may have been using that device. But barring external corroboration, it's impossible to put somebody behind a screen.
Now, in terms of, reaching conclusions in digital forensics, you have to make determinations based on a number of factors, correct?
Yes.
Okay. What, if anything, did you do to arrive at the conclusion that...
Objection, leading?
On January 9th.
Sir, sustained as to leading.
What, if anything, did you take into consideration in arriving at your conclusion on January 9th, 2023?
For that particular date?
Yes.
I took into account all the information I had at that time as to what was the more likely scenario based on what I had at the time.
Okay. And what was your determination based upon this particular executive summary?
That based on what I had at the time, it indicated that the device owner was using the device.
Boom, that's big.
Okay. Now, you've put in this summary January 17th. Is that a significant date?
Yes.
Okay. What's the significance of that date?
That was another date that an account was created.
And was that the FetLife account?
Yes.
Okay. And what's the relationship, if any, between the Gmail account that was created on January 9th and the FetLife account that was created on January 17th?
The Gmail account that had been created on January 9th was the email account that was used in the creation of the FetLife account.
Okay. And were you able to determine through your expertise who had control of the device, Christine's devices on that day?
I was able to determine that it was her phone involved in creating that device. I was able to determine that it was her phone used in the creation of that account based on a variety of returns.
And did you make any conclusions at that time that she had not given up her devices?
I had nothing indicating loss of dominion and control at that time.
Okay, and that's what your finding was as per that particular day, correct?
Yes.
Has that changed?
Yes.
When did that change?
A co-defendant admitted to using the devices.
Okay. Has it digitally, in terms of digital forensic artifacts, has that changed?
No, the zeros and ones did not change.
Okay, so, and zeros and ones, that's binary, right?
Yes.
So your conclusions based on zeros and ones are still the same?
Yes.
The only additional factor is the co-defendant adopted a different story.
I was provided additional information that had to be taken into account, yes.
Okay, meaning she told the story that she told the other day here?
Yes.
Okay. Were there any other conclusive digital artifacts that were different in the creation of this report other than the co-defendant testifying differently?
I'm sorry, can you ask the question again?
It wasn't a very artfully worded question. Were there any, so we were just talking about digital analysis, the ones and zeros, right?
Mm-hmm.
And that's the thing that you oftentimes work with, correct?
Yes.
And what your testimony was is that the co-defendant's testimony was the thing that changed relating to the January 17th that we were just talking about.
Yes, context is important.
Okay. And was there something other than her accepting other than her telling the story that she told that day, was there anything about the traditional digital forensics that you had analyzed that had changed?
Not that I recall.
Okay. And that was January 17th, correct? Or was it the entire report?
I was speaking to it as an aggregate.
Okay. And did you have an opportunity to be part of the questioning of Juliana Perez Magalhaes?
No, I was not part of that.
Okay. Were there items within that interview that was in conflict of your findings in digital forensics?
Objection, foundation.
Are you only a foundation?
Okay. You heard the testimony, correct?
Yes.
And I'm speaking of the first time she told the story on October 25th, 2024. You heard those interviews, correct?
Yes.
Okay. And so my question is, did you see conflict? What, if any, conflict did you see with your digital forensics findings and her statements on that day?
Nothing is immediately coming to mind.
Okay. Would you have seen her video where she's talking about, where Eric Klingen is asking if anybody was on FetLife on a certain day?
Yes, I've seen that.
And your knowledge of digital forensics, you knew why he was asking that.
Objection, leading.
All right, I'll sustain as to leading.
Did you, in fact, did you have any idea why he asked that question?
I can't speak to why people choose to ask the questions they do in an interview.
In terms of your digital forensics findings, though, did it make sense why he asked that question?
I think it would be relevant information.
Okay. And she didn't answer it correctly, correct?
Objection, leading.
Sustain as to leading.
What, if anything,
why doesn't he ask for
she,
hostile witness privileges? He was investigator for the state on the other side.
Strike that question.
Okay.
Ask the judge to treat him like a hostile witness.
After you heard that she had recanted and told this story, did you see an opportunity to be involved in the questioning of her?
I think I know what you mean by that. I would have liked to have been involved, but I was not involved in questioning her at all.
Okay. Looking back on the interview, if you had been involved, could you have assisted them?
I believe so.
Okay, and who were the people that were in the interview room?
Objection, foundation.
Well, if you want to have a foundation, if he knows.
There were, when she was interviewed, there were a number of detectives in there, correct?
I believe so.
Do you know any of the detectives that were in there?
Yes.
Okay. And did you have an opportunity to talk to them about your ability to assist them in her story?
Prior to that?
Yes.
No, I did not have an opportunity.
Were you aware that she was doing that prior to her story?
I was not aware until after it had already taken place.
Okay, so they didn't and were you the digital expert for this case at that time?
Yes.
Okay, so what, if anything, did they do to get information from you to make it a more accurate questioning of Juliana Perez Magalhaes?
I wasn't able to provide them anything because I didn't know what was happening.
Okay. And no one told you that?
Correct.
Okay. The digital forensics, no, so you were transferred, correct?
Yes.
When did that occur?
Roughly a year ago.
Okay. Okay. And what you're doing now is a different form of digital forensics?
Objection asked and answered.
Overruled, allow it since.
I'm using the same skill sets, yes.
Okay. But you don't get involved in cases like this anymore in digital forensics?
No.
Okay. When you were still within digital forensics, were you ever asked to change your executive summary that we've looked at?
To change it?
Yes.
I was asked to review it in light of the proffer.
Okay. Were you ever asked to go line by line and fix the conclusions?
Objection leading.
What, if anything, were you ever asked regarding your digital forensics executive summary?
To review it in light of the proffer and ensure I could explain what I had put in that executive summary.
And did you do that?
I reviewed it.
Okay. Was there a change in this document based upon that review?
Like I said, the zeros and ones did not change.
Okay. Is that why you were transferred?
I can't speak to the exact motives behind a transfer.
He's trying to save his job.
Okay. So you were never told why you were transferred?
There was a discussion about the transfer, yes.
Was it related to your executive summary?
It was related to my work in the Banfield case.
Okay, and your work in the Banfield case, is it fair to say that it was...
Objection leading.
Was there any other work in the Banfield case other than digital forensics for you?
For me, no.
Okay. So let's go through that document if we can. Can you still see it?
Yes, sir.
Okay.
He's having to go here with basically a hostile witness. This is somebody who works for the prosecution side, okay? Somebody who works for the police. He's having to go through this with somebody. He has to drag it out of them instead of his own expert witness because he couldn't get this documented as an evidence.
Looking at the January 18th until February 23rd discussions in your report. Do you stand by those same conclusions in those bullet points?
As far as the activity of the devices, yes.
Okay. And the ones and the zeros?
Yes.
And so the only thing that changes that section, and I can keep scrolling if you need to see it, is the fact that...
Judge, I'm sorry, can counsel explain where specifically in the document he's referencing?
The section of January 18th until February 23rd, 2023. Should be on the screen. I scrolled up to it.
Judge, I see a section titled 1219 to 224.
At the very top of the screen, he has the dates.
I see. Thank you.
Okay.
I was just trying to include that whole
That's
section.
fine. I think she was just looking on her laptop, too.
Okay. Is there anything of the ones and zeros, the binary language, that's changed in that portion of this summary?
No, the data extractions remain the same.
Okay. So the only change is that the co-defendant gave a different story.
Additional evidence came to light, yes.
Is that the additional evidence?
Yes.
Okay. Do you see the section that says February 18th, 2023?
Yes.
It says starting at 22:44 hours, Christine utilized her
Judge, I'm going to
CB.
object to reading from the document. He can question the witness.
All right, I'll sustain the objection.
Okay, do you, that statement that I was just starting to read, is that still the same?
As far as what the device was doing or the account was doing, yes.
Okay. And the only change that would change that would be that Juliana Perez Magalhaes changed her story?
Yes.
Okay. Let's look at February 19th, 2023. Have you read those 3 bullet points?
Yes.
Okay. And same question. Is there anything that has changed regarding the ones and zeros, as we talked about, in that section?
No, the data remains the same.
Data remains the same. And have you ever heard the term digital forensics don't lie, people lie?
That's a phrase.
I've heard it.
Have you ever heard it?
Yes.
Okay. Now, talking about February 19th, the only thing that's changed is Juliana Perez Magalhaes has changed her story, correct?
Yes, the data remains the same.
Data remains the same. (219) to 2023, February 19th, until February 24th, 2023. This references Telegram communications. Do those items remain the same?
Yes, the data did not change.
Okay, so I don't want to
jury
put
can't
words
see
in your
these
mouth,
items.
but pretty much everything is the data hasn't changed, correct?
Correct. Context did.
Context, and the context is in the form of recantation of Juliana Perez Magalhaes.
Yes.
Okay. And your conclusion? Same thing?
Yes, sir, the data still hasn't changed.
Okay. And that hasn't changed except for the recant of Juliana Perez Magalhaes. Your
Objection calls for hearsay.
I'll sustain the objection if you want to rephrase.
Who were you asked to change your executive summary by?
Again, I don't believe I was asked to change it. I was asked to review it in light of the proffer.
Okay. And so when you reviewed it in light of for the proffer, was there ever another executive summary created after that?
No, I did not create another document.
Okay. So you just reviewed it as you were asked to do?
Correct.
But there's no actual executive summary like you did in this situation?
Correct. I did not create another document.
struggling to get there. He's buffering. Glasses on, glasses off, glasses on, glasses off.
Other than listening to the interviews that Juliana Perez Magalhães gave, did you ever deal with her directly?
No, I had only when I got her phone from her when she was arrested.
Okay. So is it fair to say that you were never in a position to challenge any of the things she said?
I conducted no interviews with her. That's correct.
Were you able to observe whether she was ever challenged on any of the things she said?
Only with the interviews that have been recorded.
Okay. And do you believe that she was challenged on what she was said?
For the fourth time.
I'm not sure that that is relevant. His belief.
Yeah, I'll overrule as to relevance.
I'm sorry, could you ask the question again?
Do you believe she was challenged in those interviews?
I think that's a relative term. I can't speak to what the person asking the questions was thinking at the time.
Let me see if I can get us to a point where we're understanding each other. As an investigator, if you think that something may not be right, whether it's based on digital forensics or anything, you challenge them, correct?
Yes.
Okay. And that's what you would do if you were in a situation where you were interviewing based upon your work, correct?
My questions would have likely been different, but I can't speak to why somebody would ask what they would ask in an interview they're conducting.
So if somebody says something, generally, if somebody says something that's wrong, you don't challenge them?
I think I would.
Okay. In watching those interviews, were they ever challenged? Was she ever challenged?
Judge, objection calls for speculation. Again, he's testified already that he doesn't know what was in their minds when they're asking questions.
Speculation.
Well, I'm asking him about his review of the videos. It's not, it's essentially, it's his.
I'll overrule the objection. Go ahead. If you can answer.
Yeah. Re-ask the question, sir, please.
Watching the interviews of her recant, you weren't there, correct?
Yes, I was not there.
Did you think that she was challenged when she gave the story that she gave?
It appeared to be more of a free-form interview. I did not see direct confrontation on things in that interview.
Okay. And when you say free-form, you mean she was just able to tell what she wanted to?
Well, they were going through the details.
Okay, so she was asked about a detail, and then she was able to give a story?
Pretty much it was a question and answer format.
Okay. And I guess my question is, I use the term challenge. Were there people questioning what she was saying?
In light of?
Any of the topics?
I don't remember anything specifically.
Okay.
If it feels like defense is trying to pull teeth,
What
it's
were your
because they are.
conclusions in your executive summary that you wrote before her recant?
That based on the digital evidence I had at the time and the facts known at the time, it indicated that the device owner was responsible for the activity on the device.
And that device owner?
Christine Banfield.
That's as much as I think they're going to get from this witness.
I have no further questions.
All right, cross-examination.
Yep.
Thank you.
You may just put this down, or do you need it? You may take it away.
Or just put it down. It's fine. Good afternoon, Detective Miller.
Good afternoon.
All right, so
See if he gets more friendly here.
you stated, barring external corroboration, it's impossible to put someone behind a screen. Isn't that correct?
There needs to be corroboration of some sort, yes.
All right, and in this case, when you dug into Christine's phone, Christine's laptop, the information that you received from the external sources, Google, Apple, were you able to put someone concretely behind the screen?
At times, yes.
But throughout the context of all of the conversations that you saw occurring, the activity that you saw occurring on Christine's phone, could you conclusively opine as to who was behind the screen?
No.
Okay. And when you wrote this report that Mr. Carroll has referenced, you used the phrasing, Christine did this, Christine did that. Is that correct?
Yes.
Okay. And after additional information and further investigation, you would have changed that to Christine's phone or Christine's laptop. Is that correct?
Correct.
Because again, you can't put someone behind the screen in this case, can you?
Not for everything, correct.
Is that why you're demoted?
The evidence itself did not change, correct?
Correct. The data did not change.
You did not change the evidence, correct?
No, I did not change the evidence.
You reviewed how many terabytes of data in this case?
8.
A lot.
A lot, okay. And in all of that, there was no ability to reach a conclusion that one person was always operating on FetLife, was always operating on Christine's phone when interacting with the Google account that was created to manipulate the FetLife account. Is that correct?
Correct.
All right. There are no artifacts contrary to Juliana Perez Magalhaes' statements regarding the creation of the account, are there?
Not that are coming to mind, no.
And the only changes that you would have made here is, again, to clarify that there are points at which you cannot tell who is operating the device.
Yes, I would have clarified. It's very difficult to speak about devices constantly saying this person's device, that person's device. I did it with Joseph Ryan's devices, Brendan Banfield's devices, Juliana's devices all throughout. I just called it the person who owned the device using.
All right, so in this case, I got louder. The digital forensics may not lie, but they didn't provide us with any conclusive evidence of who was operating Christine's phone when the Google account used in conjunction with the FetLife account was created.
Correct.
Okay. You were also asked about your review of Juliana Perez Magalhaes' original proffer that occurred on October 25th. Is that correct?
Yes.
Okay. Were you aware that there was another interview with Juliana that occurred in February?
Yes.
Okay. And did you receive information from watching the October proffer about what was going on in the room between the detectives and the attorneys that were present? Did anyone show you the notes that were passed? Have you had the opportunity to talk to those individuals about what they might have whispered about when they stepped out of the room?
I did not discuss that with anybody.
Okay, so you have no idea what, if anything, went into the questions that she was asked and whether or not there was effort made to confirm that her story had additional corroboration, do you?
Correct.
Okay. Judge, I don't believe I have any other questions.
Right.
Thank you so much.
Redirect.
Sir, do you know why you as the expert...
Wait till you get to the microphone, please.
Do you know why you as the expert in digital forensics was not called in the Commonwealth's case?
I don't.
Were you ever told anything about that?
Objection calls for hearsay?
Overruled.
Yes.
I just know that they were not advertising it, that they were having the proffer at that time. I found out afterwards it had already taken place.
No, I'm talking about for the trial, for this trial.
I'm sorry, ask your question again then.
So it started with, do you know why you weren't called when you were the expert in digital forensics for this case?
again, I can't speak to somebody's motivation for not including me.
Okay.
That wasn't the question, though. Do you know why?
It's not a hard question to say when you're not watching someone on a device to say digital forensics can't conclusively determine who it is behind the device, correct?
Can you ask it again, please, sir?
Sure. It's not a hard question to ask someone like yourself, you don't know 100% who's behind that device. Isn't that correct?
Objection
That's
leading.
a bad question.
I'll sustain as to leading if you want to ask.
What is the likelihood of being able to say someone is using their device with 100% certainty without seeing the person?
That's difficult to do.
Okay. And that's one of the reasons why digital forensics is a valuable tool, correct?
Objection, counsel's testifying.
Oh, overruled, if you can answer.
Yes.
And it's because of, well, the factors that you've described for the ladies and gentlemen of the jury. That's how you arrive at conclusions, correct?
Objection leading.
Yes.
But they're not.
Objection leading.
How many times that you've arrived at successful conclusions where you were 100% certain the person who was behind the device?
I would say only in circumstances where somebody admitted that they were using the device.
Okay. Or you had a camera on them or something like that?
Correct, some kind of corroborative factor.
Okay. Do you have any idea why you were excluded from any of these meetings regarding the Juliana's recant?
I can't speak to people's motives to not including me.
Okay. Was there anyone else who was covering the digital forensics arena in your stead?
In general or for a meeting in particular?
For this case.
No, I was pretty much the one who did the analysis.
So you were the expert?
Yes.
And who would rely upon your expertise in the ongoing investigation?
The lead detectives.
Okay. And are you talking about Detective Bryant?
Yes.
And Detective Goodell?
Yes.
Okay. And what was the flow of information as you found digital forensics? Did you give it to them?
Yes, everything that I processed was ultimately provided directly to Kyle Bryant and other detectives involved in the case.
And did you ever, so I'm asking in the context of like a math equation, did you ever show your work or did you just show your conclusions?
I went through the artifacts with the detectives.
Okay, and that would be Kyle Bryant?
Yes.
And Tom Goodell?
Yes.
Any other detectives?
There were a lot of people in meetings.
Okay,
about
so they
this
were,
case.
okay, so you're talking about meetings, but did you ever go in and just talk to them in a granular level as to why you arrived at the conclusions you arrived at?
Yes.
And how often would that happen?
There were multiple occasions that I got to a granular level.
Okay. What about the command staff? Did you ever get into the granular level with the command staff on the digital forensics?
There were multiple meetings where command staff was present, and I outlined why I came to the conclusions I came to. As far as sitting down and going over every artifact, no.
Okay. And would you have been invited to do that by the command staff?
Objection calls for speculation.
I'll sustain that.
Were you ever invited to come in and give the granular details, no matter who they were?
I don't recall providing granular details to command staff.
Okay. And granular, we're talking about to the nitty-gritty, right? Just so we're using the same terms.
Judge, objection is to form. I'm not sure how nitty-gritty is different from granular.
I'll sustain that objection.
Objection, nitty-gritty.
How would you describe granular in the way we're talking about
Not the nitty-gritty.
Painstaking detail, like getting into why that artifact is the way it is, how it came to be there, going through that way. So some of them were down to that level, but not the entirety of the case, no.
Okay. And when you say some of, are you speaking to the people when you say some of them?
Yeah, there were different times throughout this investigation where I would sit down with various different people, and depending on what was desired, I would go through exactly how I arrived where I was. Some people wanted overview, some people wanted to see down to the detail.
Okay. I have no further questions, Your Honor.
All right, is this witness subject to recall again, or?
Sure, why not?
Okay, so you're still subject to recall, Detective, so
Sure,
does your
why
testimony
not?
with anybody, and you're still subject to the rule of
He
witnesses,
says,
okay?
great.
Thank you, Your Honor.
All right, thank you. You're free for today, though, I think, now? Yes?
Yes, it's 4.
Sure, he's free for today, though, right?
Yes.
Okay, thank you.
May we approach? We're looking at calendaring now. The state regained a lot of ground, but we got a little bit, a peek behind the curtain, a tiny bit, as to the drama, the disagreement in the investigation, the back and forth that happened there. Okay, hold please. Let's see. They're up at the bench. Continue the discussion. Who do you have left? He said we'd have today and tomorrow, but a lot of that got chopped. Let me jump around and see what. Nobody's moving. Nobody's talking. Sorry, I'm checking all the channels to see what's going on. Just changing the channels. Ignore me. Just ignore me. It's all good. Okay. Long sidebar. I recant my told you so. All right. It's all good. It's all good. I make mistakes all the time, and I got caught in one today. Like this judge, I do as well. She's fair. She's nice and fair down the line. She's calling balls and strikes the way she sees them. She's good. We haven't heard a lot from her. I look forward to the very end of the trial. That's usually where we hear the most and get the most personality from the judge. Trying to just view body language here at this sidebar to see what this means. I'm syncing up all my feeds again. Okay. Boom. Boom. Okay, we're in sync again. First try, nailed it. All right. So now he'll call recall the detective, possibly. Possibly. I think it's early home time. I've been trying to play this through my head, thinking of all the evidence we've heard, and saying what would have to be true if the au pair arranged everything. What would have to be true for this to actually be a complete surprise to Brendan? And he had no idea that this FetLife thing meetup was going on. And the au pair, the au pair just happens to be like, hey, some guy just showed up at the house. I'm sorry you're destroying McDonald's bathroom right now, but you need to come right now. Some weird guy just showed up at the house and ran in. What would change is we've only got the au pair's story, so there's not a lot of details that would have to shift, I think, for that. Of course, we'd have to say, how do we explain the windows, right? How do we explain the McDonald's trips? Why is he changing his routine?
All right, ladies and gentlemen, we try the best intentions to get everything lined up as we can, but it appears that the defense at this point doesn't have any other witnesses that are available today. All right. So what I want to do with you is if tomorrow we can start at 9:30 and possibly go to 5:30 because I got to make up this hour because I'm chasing a snowstorm. Okay. So 9:30 to 5:30 tomorrow. If that's available for everybody, can we do that tomorrow, 9:30 to 5:30? And I know we had talked about no Fridays. The attorneys wanted me to float with you if you were available for this Friday. If you're not, that's fine, because I told you no Fridays. But if you get back there and you can let the deputy know if all of you are available for Friday, we could do testimony on Friday. Just this snowstorm is just, I'm trying to chase it. I really am. And I want to get as much in as I could before that occurs on Saturday night. So allegedly. So we will see, but you never know around here, but I just a little concerned about it. So if you could just let the deputy know, and if you don't know tonight or you'll know by tomorrow whether or not Friday is an option, just let her know. And if it's not, I understand because we had told you no Fridays, okay? So anyway, but you're done for tonight.
Yeah. Do we risk the following week after February 6th?
No, we don't risk it. We are definitely ahead of schedule. We will have this case to you next week, depending on the snow. That's what I'm worried about, is if we get 12 inches of snow in this area, we might be out for 3 days next week, and we might not be back till Thursday or something like that. Hopefully not. Hopefully we can get the roads cleared and get you in here as quick as possible.
Virginia now hiring
it's my decision
snowplow
whether
drivers.
to close the courthouse, so believe me, I will be trying to get it done as
Bring
we
your own
can, okay?
snowplow.
But I just want to keep that in the ballpark, so that's why I'm trying to get the Fridays done, just in case, because I just don't know about next week, okay? But even if we come in Thursday next week, we will still be done by February 6th. I'm pretty confident in that, okay? All right, so have a good night. Don't talk to anybody about the case, and don't do any outside research, please. All right, thank you. Have a good night.
As they leave, let me tell you just this little bit. Natalie L., under that theory, who stabulated Christine? It would be Joe under that theory. Say Joe was arranged to be like the pretend guy, and he's like, what if I want to do it for real? Or what if it got a little carried away, and then he panicked? I mean, there are a lot of...
So we'll do 9:30 to 5:30 tomorrow. Are you working on jury instructions? Are we getting those done?
Yes, ma'am.
Okay, so maybe even if they can't come in on Friday, maybe we can do jury instructions on Friday. Okay, figure it out. All right, thank you. We'll see you tomorrow at 9:30.
All right.
And with that, the judge is gone. She gone. All right, that wraps it up. I don't believe it for a minute. I'm just saying what would have to change. One piece of evidence that supports Joe doing it, and this is big for the defense. We pointed this out earlier today. There is no DNA from Brendan on the knife. He was excluded from the DNA test from the handle and the blade on the knife. There is DNA from Joe on the handle and Christine on the handle, and there's DNA from Christine on the blade of the knife. That's big. That's something, and that supports it. It doesn't tell the whole story, but they have them in the timeline to clean the scene. That's another thing that counts against defense. You've got the early 911 call, the long pause, and then another, oh, surprise, surprise, after we called 911 and hung up earlier this morning. In the meantime, we've stumbled upon a crime. That definitely counts against him as well. And then the maneuvering around the scene. Could have been wearing gloves. He wiped it off. I mean, he almost had time to run it through the dishwasher to clean it at that point. All right. Blood DNA. There's no one's prints on the knife. We didn't get prints on the knife. It was blood covered. It was just DNA. But, Brendan didn't have any injuries. There was no bleeding. It's like he laid his arm on me or something is all we got. He may have been holding Joe at gunpoint. There's a lot of evidence against Brendan. I agree there is, a ton. Juliana never said gloves. No gloves were found at the scene. They were covered in blood, but the blood was limited just to the bedroom. So in that, he's going to tell his side of what happened. If he does tell his side of what happens, if he does talk, he needs to fill in all these blanks, all these stories. We need to understand how the evidence fits together under a different scenario than the one that Julianne told. Because right now, that's the only thing running through the jury's mind. All right, Brendan, master planner. Yes, we see that. With that, that wraps us up for the day. And you've heard the judge sort of tell us about the timeline going forward as to what we can expect this week. Tomorrow, more witnesses for the defense. Possibility of a Friday. They're not supposed to work Friday. There's a possibility of Friday evidence. Depends what the jury says. We'll probably find that out in the morning. If not, on Friday, we'll be going to the other case, the New Jersey case, and catching up on that one. Then also on Saturday, we'll be catching up on that one. And then, depending on the snowstorm, we might stick with that one for a couple days. Depends what happens here in Virginia, or up in Virginia. So, well, that was fun. It was a lot of fun. All right, to the person who said, can we talk on Discord about upgrading tech? Now would be a good time. Now would be a good time because we're done for the day here. It's only 4:11. But if you are in the path of this potentially dangerous storm, I say, well, it's dangerous. It's going to be dangerous for somebody, but I just don't know who right now. It's moving around quite a bit. I was watching Ryan Holyall's updates, and he's like, it's shifted a ton. Most of the patterns now moved it way up north. But some still have it going south. If you're in the path, please prepare for it. This is not the sort of thing you want to be caught off guard on. Do what you can. If you need help, reach out to somebody to let them know you might need some help preparing. And we want everyone to stay safe and warm throughout the storm. Tonight when you go home, please hug the people you love, smile at someone, make their day just a little bit better. Please stay safe till we go live again tomorrow. We're starting at 9:30, which means we have to, the court started at 9:30. We're starting at 9:15 tomorrow, half an hour earlier than normal. And once again, absolute thank you to just some fabulous moderators who literally make this channel run. I could not do this without you. You guys are amazing. Thank you. Starting a bit early tomorrow, more of the regular schedule, I guess you could say. But be safe. We'll see you all in the morning, and have a good night. Peace out. Bye.
Best friend. I'm going to sustain my own objection.
I'm not a cat.
There's nothing in the order.
You're talking about stuff that is not wrong.